Good
My mic
morning,
is
Chief
off.
Justice.
How are you?
I'm fine, Chief Justice, under the circumstances.
All right. You are a regional magistrate.
Yes.
Where are you stationed?
I'm stationed in Mankweng, but I'm currently in Polokwane.
Where your foray into the legal field started with you obtaining a BProc degree. From which university was that?
University of Limpopo.
And then you did an LLB.
Yes, Chief
and
Justice.
with success. Where did you obtain the second degree?
Same university, Chief Justice.
And then you did an LLM.
Yes.
Same university.
Yes.
You started out as a prosecutor in 1995.
Yes, Chief Justice.
And you remained in the NPA until 2003
Yes.
and became a magistrate.
Yes, I became a magistrate in 2003.
Then in 2016, you were promoted to regional magistrate.
Yes, Chief Justice.
So how long have you been in the magistracy? For 20?
It's more than 20
1
years, Chief Justice.
Yeah. And have you had an opportunity to do civil work either in the district court or in the regional court?
In fact, the reason why I'm now stationed in Polokwane, Chief Justice, is because I'm now dealing strictly with civil cases since 2018, July 2018 to present.
All right. When did you start acting as a judge?
I started on the 7th of August 2023.
And for how long have you acted?
When I count the weeks, it's 14 weeks, Chief Justice.
And what kind of work did you do in this 14 weeks?
I did criminal work, I did civil work as well.
What kind of civil work? Civil cases?
RAF matters and all kind of civil work that was there. In fact, when I started, my first 3 weeks, I was in the motion court in 2023. So I did the motion court for the whole 3 weeks. That is opposed, unopposed, agents as well.
Did you sit in the civil trial court?
Only in rough matters.
All right. And did you get to do civil appeals?
Yes, I did.
Did you get to write judgments?
Yes, I did, Chief Justice.
About how many?
I've got 14, no, I beg your pardon, I've got 20, I've got 22 judgments, and 8 of these judgments, it's criminal judgments, and then the rest is civil judgments.
Any of them reported?
No.
Okay. You've done other things outside the judicial seat. You've written an article.
Yes, Chief Justice.
In labor law, interestingly.
Yes.
That was published. Where did this interest come from, and why have you not written again?
The issue of precautionary suspension that I wrote about, it's something that a family member was suspended for a period of about a year, without a charge sheet, without a disciplinary inquiry. And I then had an interest in wanting to know more about precautionary suspensions based on that.
Yeah, that's good motivation. You are also involved with mediation programs and have done some work there. Can you just tell us a bit about this project?
In 2012, I went to the USA, specifically in California, UC Hastings University. And when I was there, there was something that drew my interest, and that is the fact that the students of that university, those that were studying ADR, that is Alternative Dispute Resolution, were given an opportunity in courts to do mediation. So when I came back, I then spoke to the head of the court, I spoke to the chief magistrate, I spoke to the University of Limpopo, and I made this proposal to them. And fortunately, they acceded to the proposal. And what I did, I then arranged that final year students of the University of Limpopo that were studying alternative dispute resolution could get an opportunity to come to the court, the Mankweng Magistrates Court, because at that time, I was still at the Mankweng Magistrates Court. So they would get an opportunity to come and mediate in real cases, in the small claims court cases, and I had to supervise all that process.
All right. And you assist with judicial skills training to a variety of interested parties called attorneys, advocates, prosecutors, and district magistrates who aspire to become regional magistrates.
I do that, Chief Justice.
All right, I'm going to hand over to Judge President Pachudi to put questions to you, if he has any, that is. JB?
Yes, thank you very much, Chief Justice, for the opportunity to put questions to the candidate. Greetings to you.
Good
Madam
morning.
Ngobeni.
Good morning, JP.
Thank you. Let us talk about your experience on the bench as a magistrate, district magistrate, as well as later as a regional court magistrate. Would I be correct that in your cumulative period of 23 years of court experience as a magistrate and regional court magistrate, you've been exposed to both the civil law, as the Chief Justice has already alluded or probed into, criminal law, and procedure, and the law of evidence when adjudicating on a variety of cases. Am I right?
That is correct, JP.
Now, did the 23 years of judicial track record enhance your ability to run a courtroom?
That is correct, JP.
And did you experience any material difference as to the procedure, especially criminal procedure, as well as how to adduce, rather to collate evidence that obtains in the lower court as well as in the high court where you've acted? Did you note any material difference?
I beg your pardon, JP.
Yes.
In the regional court especially, we do cases that the High Court has jurisdiction over. That is in the criminal matters.
And that will be your example, your murder cases?
Murder cases,
Your
rape cases,
your
yes,
robbery with aggravating circumstances?
Yes, we apply the provisions of the Criminal Law Amendment Act 105 of 1997. That is what is commonly referred to as the minimum sentences. So we do that in the regional court, we do that in the High Court. So as such, I don't have a problem in dealing with criminal cases in the High Court because I deal with them, the same cases in the regional court. Not that I have a problem with dealing with civil cases. That is the case as well.
Yes, and the law of evidence is the same. The rules of evidence are the same, there's no difference.
Yes, JP.
Okay. Now, with that kind of knowledge, it has rooted itself in a period of 23 years.
Yes, JP.
Right. Now, you mention at page 15, paragraph 813 of the questionnaire,
15.
that, yeah, that is, that from the period 2003, before your appointment as a magistrate for Mankweng district, you were also appointed as a magistrate for Giyani district,
That is correct,
which is
JP.
not far from the Thohoyandou area. Am I right?
Yes, JP.
So, can one say that you're quite familiar with the demographics of the Thohoyandou area?
In fact, JP, I'm married in that area for over 20 years. So I know the demographics of that area.
Yes. And of course, in your you've mentioned that you've now have 14 weeks credit, acting credit. No longer 9 as it appears there, because that was at the time when you submitted or completed the questionnaire.
That is correct, JP.
So all in all, you say it's about 14 weeks of acting stint
Yes.
in Limpopo
Yes, JP.
Division. And that you presided therefore over a fair number of criminal cases, that is criminal trials,
That is
at
correct.
high court level,
That is correct, JP.
and also in civil trials, including both criminal and civil appeals.
That is correct, JP.
And in doing so, you also had occasion to write on behalf of the full court judgment in the Muneri case, for example.
Yes,
Do
JP.
you like to share us just briefly the succinct principles you've identified in that court, in that judgment?
JP, in that judgment, there was a serious dispute of facts. And because of the fact that there was a serious dispute of facts, one would have expected that the Korakuo should have either dismissed the application, or if not dismissing the application, then the Korakuo should have ordered that at least oral evidence be laid before it, or refer the matter for trial. And that is precisely what the Court of Appeal did, the full court.
Yes. Now, you presently reside in Polokwane?
Yes, JP.
If considered for appointment, would you be ready to or willing to relocate to Thohoyandou?
Yes, JP, as I've already said that I'm married in that area. I think my husband will actually be happy that we will then go back home.
That court in Thohoyandou had, before the advent of democracy in 1994, being established along the old separate development policies. In other words, it was an independent court in an independent state, then called Venda. And its establishment has always just been 3 posts at a time. And since 1979, do you know whether there has been any female judge appointed for that court up to today, which is 2024?
I
Or
know that
is
currently,
that is to your knowledge.
I beg your pardon, JP.
Yes,
for,
no
for
problem.
interjecting.
Yes, your answer?
Thank you.
Do you know whether Has there been any female judge there?
To my knowledge, not JP, because even currently, I know that there are two sitting judges, male sitting judges, currently.
And I'm just saying that, so if appointed, you will be the first in the history of that court, female judge.
That is correct, JP.
All right, any of your judgments that you've produced in this short space of time, especially the civil ones, anyone that has been overturned by the Supreme Court of Appeal?
To be honest, JP, none of them were taken on appeal, as far as I know, because I take it that before it could go on appeal, I would be notified, because the leave to appeal will definitely be brought before me.
Yes. So
One of them that I produced, I got a notice. In fact, I got a request for a date for the parties to bring an application for leave to appeal. But on that date, instead of them appearing, the matter was then removed. And that is as far as I know with regard to appeals. So in other words, there is not any case that I know that was taken on appeal.
And as to reserved judgments, do you know of any reserved judgment which has been outstanding over, well over 3 months period?
I don't have reserved judgments, JP.
Yes. Thank you, Chief Justice. I have no further questions.
Thank you, Judge President Patuti. Premier Ramatuba, do you have questions for this candidate?
Chief Justice, and good morning to Commissioner, and morning, Advocate Ngobeni. I just want to make a follow-up on what the President has just asked. Advocate, according to you, as you were responding to JP, for the past 45 years, the Toyando has never had a female judge, and which is a confirmation that we still have serious challenges when it comes to transformation within the judiciary. This is also evident by the fact that it's only after 30 years of our democracy that even the Chief Justice now will be a capable woman. My question to you is that, as a woman who has made it this far within the very same system that is very difficult to transform, what is it that you have done in your current position as a magistrate in terms of mentoring and uplifting fellow women within the judiciary? And what is it that you are going to do once you are affirmed or recommended and appointed as the judge of that a court which has never had a female for 45 years? And I just really want to understand because today marks 85 years since Charlotte has departed, and one of the issues that her teachings in her famous quote is about as when she talks about the work we do is not about ourselves. She further indicated that as you rise, you must take along another girl child with you. So as a girl child who grew in the rural dusty streets, what is it that you have done and what is it that you still are going to do to make sure there is transformation within the judiciary? Thank you, Chief Justice.
Thank you, Commissioner. Thank you, Premier. If you look at my questionnaire, you'll see that in February 2024 to March 2024, I was involved in training. And this training was specifically for people, and there were a lot of women in that training. And that is people that are aspiring, lawyers that are aspiring to become regional magistrates. And I'm very passionate in that, because if you look at my questionnaire, you'll see that that was not the only time that I participated in this kind of program where we train women who are interested or aspiring to be regional magistrates. So I'm making that difference as a woman. And even UNISA students, we take along UNISA students. I remember that in this year, I had UNISA students come into my court to come and observe as to what is happening in a courtroom, because most of these people, especially the UNISA students, do not have that practical knowledge of what is actually happening in court, because of the fact that theirs is a distant learning. But there were women that came who I allowed and mentored them with regard to court proceedings. And I've already mentioned the fact that February and March this year, I was involved in such a program. Thank you.
Was that your only question, Premier?
Yes, that was my only question.
Thank you. Marumahai?
Thank you very much, CJ. Good morning, Magistrate.
Good morning, Professor Marumahai.
I have two questions for you. The first one comes from what you stated earlier on the judgment that leave to appeal was refused by a single judge, then leave was granted by the Supreme Court of Appeal to the full bench that you spoke about earlier on.
Yes.
And you gave two options, that it's either the matter is dismissed when you use the word serious disputes of fact, or the matter can be referred to oral hearing. Obviously, there must be a basis why the matter will be referred to oral hearing. But let's say that option is not there. What will then lead to the court dismissing the matter where there is a material dispute of fact which cannot be resolved on the papers? What will be the basis? Which rule will the court actually use to dismiss the matter, or will the court just dismiss the matter without applying a particular criterion or rule?
That is Rule 6, 5G, and that decision is based on the Plascon events rule that if there is a dispute of fact in an application on affidavits, and the version of the applicant and the version of the respondent are so far-fetched that they cannot be reconciled, then that application can be dismissed on that basis, because as an applicant, the applicant is the one that has to prove its case before a court of law.
Yes. No, thank you very much. The second question that I have for you is, I want us to deal with Rule 23.
Sorry, CJ. I want to follow up on the first answer.
Commissioner Ngobeni.
Thank you. Good morning, Madam.
Good morning, Commissioner Ngobeni.
Just a follow up on the answer to the first question, that where there is a dispute of fact, you simply dismiss it. Did I hear you? That if there are any material dispute of fact, you simply dismiss that application? I hear you.
You can dismiss, or you can refer the disputed facts for oral evidence, or you can refer the matter to trial.
Thank you, CJ.
Any other questions for the candidate, colleagues?
No, colleague,
Or there's a follow-up? Is there follow-up, Prof?
sorry, CJ, I have the second question that I had to ask.
Oh,
No,
I'm
there
sorry.
was a follow-up.
Okay,
No,
go
no,
ahead and
I
answer,
apologize
ask
for
your
that.
question.
I want us to talk about Rule 23. You don't have to worry about the number of the rule. It deals with an exception. The exception is generally referred to as one of those procedures that can assist the parties to be economical in their proceedings by actually ending the proceedings quite earlier. I just want to understand under what circumstances because both parties can raise an exception for different reasons. Under what circumstances can the defendant raise an exception towards what is pleaded in the particulars of claim? And what will be sort of the test that will motivate you as a judge to exercise your discretion to be able to uphold the exception?
The exception that is usually raised is the fact that the particulars of claim are vague and embarrassing. So that is mainly the exception that is normally raised by the defendant. It should be the defendant because the defendant will then be taking exception to the particulars of claim. But the experience that I have is that they would normally raise an exception that the particulars of claim are vague and embarrassing, and as such, they are unable to plead.
No, well, yes, that is a normal sort of claim that they will make. But what I'm trying to get at is what will then, what justifies that vague and embarrassment that they are talking about? Because anyone can stand up and say, but this pleading is vague and embarrassing for whatever reason. But what will then you, as a presiding officer, make a call that indeed it is vague and embarrassing? Like what is the meat behind it?
Let me not guess on that answer.
No, that's fine.
Professor.
Thank you very much, CJ.
Thank you, Prof. Commissioner Ngobeni.
Ms Ngobeni, good morning.
Good morning, Commissioner Nukaitobi.
Yes, now I've read the two judgments. They are comprehensive and well written, especially the appeal judgments. And you, in fact, had a better comprehension of the Plascon-Evans test in your judgment than in your answers here. So I suppose, sometimes the pressure of being interviewed, interferes with your sort of intellectual output.
That is correct.
Is that correct?
Yes, that is correct.
All right. No, that's fine. No problem. I just want to ask you on a different subject, on an academic subject. You published the article on precautionary suspension in 2013. And I don't know if you've followed up on the legal developments, because there is now a recent judgment called South African Breweries versus Long by the Constitutional Court, which says that it is not unfair not to hear, because in your article I understood you advocated for a hearing at precautionary suspension stage. Now there is no right to a hearing at precautionary suspension stage according to the Constitutional Court. Is that judgment correct?
I would caution you
Commissioner,
to be very, very careful as you
Commissioner,
answer
who
that
am
question.
I? Who am I to say that the Constitutional Court is wrong?
No, that's fine. You don't have to answer. I understand your predicament.
Commissioner Steinberg?
Good morning. First, just to salute you for the journey that you've been on. Your judgments are excellent. Your articles are excellent. So the question I ask in no way goes to ability, it goes to experience. The review from the GCB is concerned about your experience in civil law. You clearly have a very strong grasp of procedure and evidence. I just want to ask you, have you had much experience in public law?
I beg your pardon, Commissioner?
Have you had much experience in public law?
Public law?
Yes.
Maybe I don't understand the question well, Commissioner.
Administrative law?
Not that much experience, but what I can say is that the last judgment that I wrote in the High Court is the judgment that dealt with Rule 53. That is my last judgment that I wrote.
Yes.
Yes.
Let me ask you a question. If you had two applications before you, and one was challenging a tender that the municipality had awarded, and the other was challenging a policy decision of the Premier, how would you approach them, and would they be different approaches at law to those two decisions that are being challenged?
Commissioner, I haven't applied my mind to such a situation, so let me not guess.
Thanks. Thank you.
Commissioner Hassan?
Thank you very much, CJ. I'm on this side here. Advocate, I don't know if you can see me. Yes, hello. I'm just interested, I've seen on the questionnaire that you've done a number of trainings run by Sajay, but I see that quite a few of them are around magistrates. So I'm just interested if you've done any judicial, in terms of judges or aspirant judges training programs with Sajay or just generally. Thank you.
Not, Commissioner.
President Mulamed?
Thank you, Chief Justice. Good morning.
Good morning,
Ms. Ngobeni.
Commissioner.
How are you?
I'm fine under the circumstances.
Yes. I'm going to ask you a very easy question. Under which circumstances would you grant an order de bonis propriis?
That is if the order that is granted, the bonis propriis, is actually an order that is granted against a legal representative. So there must be something that the legal representative would have done that is so gross, or let me say gross, to an extent that the court finds that the legal representative has to bear the costs. Thank you.
Thank you, CJ.
Commissioner Lechonyen?
CJ, thank you so much. Good morning, Regional Magistrate Ngobeni.
Good morning, Commissioner.
CJ, let me declare upfront that my village falls within the jurisdiction of Mankweng, and that I have no ties with the Regional Magistrate. Regional Magistrate, you have spoken about mediation here. I want to check with you, if mediation was to be an option in a province like us where we have traditional leadership disputes which generates tensions in our communities, what will be the benefits of mediation if we apply it to, or as an approach to resolution of traditional leadership disputes?
Thank you, Commissioner Lekganyane. The main purpose of mediation is restoration of relationships. That is restorative justice. And the other advantage of mediation is that costs are saved, because if the relationships between the people, especially I'll just say the villagers, if there is the relationship between the villagers is restored, there won't be any need for that villager who is aggrieved to take the matter to court, spend money on legal representatives, because the matter would have been resolved. Thank you.
Thank you so much. Thank you, CJ.
Commissioner Baloy?
Good morning, Regional Magistrate Ngobeni. Yes.
Good morning,
let me do what Commissioner Lekganyane did. Your maiden name is Baloyi. Let me declare there's no relation there.
That is correct.
I'm just following on the question or what you were asked by Commissioner Steinbeck and your response. Is it fair to say that in your magistracy role and functions, you may not have come across matters that fall within public law?
That is correct, Commissioner.
And in the times that you have acted in the High Court, when you have been confronted with questions that have never arisen in your magistracy role, how have you gone about to inform yourself and to find answers to them?
Commissioner, fortunately, one has the advantage of always referring either to case law or referring to you know, there is a lot of research that one can do to keep herself abreast of what is happening in the law. As I've just said that my last judgment was a judgment on Rule 53. So I had to read so that I could understand as to what that application involves. Thank you.
Thank you, Chief Justice.
Follow up, CJ. If I may follow up, Magistrate, in the Magistrate Court, haven't you done criminal law?
I did a lot of criminal work.
Is that not public law? Surely you may not have been exposed to other areas of public law. So as any other person who can come may not be exposed to other areas of commercial law, but you have been exposed to public law.
I agree.
Yes,
I agree,
thank you very much,
Commissioner.
CJ.
Judge President Mlambo, is this the
Can I
follow-up, Prof?
Follow up.
Commissioner Stenbeck, yes.
I just wanted to say, Regional Magistrate, that I'm entirely satisfied by your answer to Commissioner Baloy. That you clearly, when you get a new issue, one can see from your judgments and your writing, you know what to do. So having asked the question, I just want to say that I'm entirely satisfied with your answer, but have full confidence in you coming to appear before you on a question of administrative law.
Thank you.
Judge President Mlambo.
Thank you very much, Chief Justice. Good morning, Regional Magistrate Ngobeni.
Good morning, JP.
You know, the Thohoyandou court is a real poser, if I may say so. When it still fell under Gauteng, I remember being the responsible JP when I had a stakeholder engagement there. The female practitioners asked to see me on their own. And the sole issue was to challenge me and those who came before me of never ever sending women judges to Thohoyandou. Were you in that group?
Not, Commissioner.
So you don't practice there? Ne?
No, I don't, JP.
Yeah. I must say it was an eye-opener because I don't know why we get into these stereotypes, but it opened my eyes, and that's when we started sending women there. I just want to understand your answer when you said, I don't know whether I understood you correctly, that you say your exposure as a magistrate or as a regional court magistrate is sufficient for you to be appointed as a High Court judge?
That is what I'm saying, JP. Thank you.
I thought you qualified your answer that only in criminal law, but not in civil law. Or are you saying also in civil law?
Also in civil law, JP, because as I said, since 2018 to present, I've been moved from Mankweng to Polokwane because I'm dealing specifically with civil law.
But as a follow-up, the regional court does not deal with civil work that goes to the High Court. That is done by the High Court in the same way as the criminal work. So how does your exposure in civil law in the regional court prepare you sufficiently to be appointed as a High Court judge?
Thank you, JP. We do divorces. We do cases dealing with state liability. We do all cases which can actually come to the High Court as well. And maybe just to inform the Commission that I've written judgments as well in the regional court. And when I counted, before I came to the interview, I counted 98 judgments.
But you do confirm that the High Court has appellate jurisdiction over your judgments in the regional court?
I do, JP.
I see. One last question, CJ. You've had 14 weeks in the High Court. And in your questionnaire, you say your overall experience is 60% criminal. I want you to comment to the comment by the GCB that says your appointment will send a message that experience in High Court litigation is not necessary to be appointed to the High Court.
My response to that question, JP, will be, am I unable to do the job in the High Court? Surely not. And that is based on the judgments that I've written. So even if my experience in the High Court is not that much, but given the job, I'm able to deliver. Thank you.
Thank you, CJ.
Just a follow-up on that. Ms Ngobeni, have you attended any courses, for example, courses that are offered by SAJE or courses that are offered at your division to train aspirant judges or acting judges?
I don't hear you well.
Have you attended any courses, for example, aspirant judges courses offered by SAJE? Sometimes courses are offered within the division, courses that are aimed to train aspirant judges.
Not, Commissioner.
Oh, thank you.
Thank you, President. Did you say you counted that you've written 98 judgments as a regional magistrate?
Yes, as a regional magistrate, yes.
That's quite commendable. It's highly unusual to hear that magistrates generally do not write judgments. I'd love to see some of those. Were they on criminal and civil matters?
This 98 is just civil, Chief Justice.
Just civil?
Just civil.
All right. No, thank you, Regional Magistrate. We don't have any more questions for you. Unless there's something you'd like to ask us or raise with us.
No, CJ. I just want to thank you for the opportunity.
You want to run away? You're excused. Thank you very much.
Thank you.